SJC-11137, Dixon versus City of Malden.
All right, let's proceed. Good morning.
Good morning, Your Honor. My name is Alfred Gordon, and together with the firm of Pyle, Rome, Ehrenberg, I represent the plaintiff appellant, Mr. Gary Dixon. Mr. Dixon is in the courtroom today and asked me to express his gratitude to the court for hearing his case to address what is a thoughtful but, we believe, ultimately unpersuasive and misguided decision by the Superior Court in this matter. The issues before the court boil themselves down to the time between question. The question as to whether after wages are due and owing under the strict...
Could you just explain to me, does the record tell us why Mr. Dixon was paid this money after he was terminated?
It does to a limited extent, Your Honor. The mayor of the city of Malden, who testified in the case, indicated that it was his decision to keep Mr. Dixon on the payroll, and that he kept Mr. Dixon on the payroll in the hopes that it would resolve the issues that Mr. Dixon had outstanding and prevent him and preempt him from bringing suit against the city, which raises the question as to what issues and claims were outstanding at the time. And at the time of the events in question, on March 21st, 2007, when Mr. Dixon was relieved of his responsibilities but continuing to get pay.
But these payments were made unilaterally?
Pardon me, sir?
The payments were made by the city unilaterally. It was not they were not negotiated payments with Mr. Dixon.
That's correct. There had been some settlement discussion between the city solicitor and Mr. Dixon's attorney at the time. Those are in the record as Exhibits 14 and 15. They are letters back and forth between counsel. The solicitor for the city of Malden had indicated that the city was willing to keep Mr. Dixon on the payroll. The letter was written on January 19th. The city said it was willing to keep Mr. Dixon on the payroll through March 2nd, and that at the conclusion of that time, he would be paid for all of his outstanding vacation and sick time. The response from Mr. Dixon through his counsel in a letter on January 31st was to reiterate the claims that Mr. Dixon was alleging at that point. One of them, the central one, being that Mr. Dixon believed that he was on a term of office that expired on December 31st of 2007, and that he was therefore entitled to be paid through the end of that year. So Mr. Cohen, for Mr. Dixon, indicated to the city solicitor that a counteroffer would be made, that Mr. Dixon should remain actively employed through February 16th, should, quote, remain a city employee through December 31st, regardless of how the city intended to use him or not use him, and that he should, of course, be paid for his vacation and at that time also for his outstanding sick leave that had accrued. There was no response to that January 31st letter, no response of any kind. Mr. Dixon received his letter relieving him of responsibilities dated May 21st, 2007, and remained on the payroll. So at that juncture, Mr. Dixon had no idea.
First or March 21st?
I'm sorry, March 21st. Thank you, Your Honor. My mistake. So on March 21st, Mr. Dixon received a letter relieving him of responsibilities, but he continued to receive pay. It was Mr. Dixon's position that he was still employed by the city at that time. He continued to receive pay. From his pay, the city continued to deduct retirement contributions. He continued on the city's payroll and did not receive a COBRA notification at that time. And so there are two possibilities in the plaintiff's perspective at that moment in time. Either he is still employed by the city of Malden, as he contended he should be, or the city has decided in some way to find some resolution that it hasn't offered him, that he's not agreed to, that keeps him on the payroll for a significant period of time, as his lawyer had demanded.
Sort of a severance pay.
Sort of a severance pay, but a severance pay as it was not required under the terms of his employment or under
Laterally offered severance pay.
not even offered, unilaterally paid. There was no communication of any kind, which left Mr. Dixon in a pickle. He believed he was still employed, which is why he did not begin his wage claim, did not file his wage claim or begin his action until after his payroll stopped on June 29th, 2007. Then he, in filing the Attorney General's complaint form, had the interesting choice to say, what date were you terminated? Well, his only termination letter was from March 21st, and so Mr. Dixon wrote that information into his wage form. But at the end of the day, he contended, and continues to contend, except that Judge Billings disagreed, that he was still employed through June of 2007. And so what that question leaves for this court is, I think, as a...
Well, when you say he continued to be employed, he didn't go into work, though, did he?
No, he did not. Interestingly, he asserted, and continued to assert at least till immediately prior to the trial in this case in 2010, that he was on a term of employment. He was an appointed officer of the city and was on a term of employment. The city's own offer of settlement on January 19th was that he immediately vacate the premises as of January 19th, but he remain a city employee through March 2nd. So the city itself understood that an individual can be not performing any active participatory work for the city and yet remain an employee of the city. It would be horribly wasteful, and indeed the mayor in this circumstance committed an act which was, in the minds of many people, horribly wasteful. But what this court has to understand is what he did not do is pay Mr. Dixon for his accrued unused vacation time. And we know that because he said so, as did the Human Resources Director when she testified in this case, as did the city in every motion that it filed in this case, and indeed as it intimated in the papers that it filed before the appeals court that ultimately led to this court.
And there was no signed release accepting or at least acknowledging receipt of weekly payments for, what was it, 3 months, in lieu of all claims. In settlement of all claims.
No, nothing signed by Mr. Dixon at any time. The court, as is clear from the evidence in the case, Mr. Dixon continued to receive his directly deposited payroll, but there was no notation on his payroll stub that he received that he was anything other than an employee of the city. Indeed, on that payroll stub and on his last payroll stub, his 50 days of accrued unused vacation still appears in the lower right-hand corner as his vacation accrual. And so for the city to assert that these payments amounted to somehow the vacation time, one would expect that number to be drawn down. Of course, it couldn't have been drawn down because, as is commonsensical, we don't have vacation thrust upon us. We request vacation and we draw down our vacation time. If the city...
Was he accruing vacation time too?
He couldn't because he had maxed out his accrual. So there's no way to know on the evidence. As of January 1st, he would have accrued immediately 5 weeks of vacation, and he carried over 5 weeks from the previous year under the city's ordinance. There is a little wrinkle in the facts there because, as the evidence made clear, it takes about a month for the city's paperwork to catch up. So his pay stub didn't show the 50 days until early February, but it went immediately from one level to the next, and he maintained it at that time. So,
could it be a different story if the scenario had been the city saying, we know under the Wage Act we're supposed to pay you vacation, accrued vacation, but we just don't have the cash right now, so we're going to pay you a third of it each month over the course of 3 months. Would you say that would mitigate the damages with regard to Wage Act or not?
I don't believe so, Your Honor, unless Mr. Dixon voluntarily agreed to do that and did not bring suit. The Wage Act, as this Court has stated in the recent Summers case, is a strict liability statute and requires payment on the last day.
We're not saying it wouldn't be a violation. I don't think that's what Justice Nance was suggesting. Yes, it might be a violation. The question is whether the payments would mitigate damages.
Then we run into the interesting circumstances, such as Justice Gantz heard when he was on the Superior Court in the Dobin case, wherein a sophisticated employee knew the Wage Act, knew that there was a violation going to occur if she did not get her payments on December 13th, on the date of her termination. The employer gave her a check on December 13th, post-dated to December 15th. She brought claim immediately, hoping to get in that window. And Justice Gantz parsed the language of the legislation to try to understand what it means for the legislature to say there are only these 5 defenses to a Wage Act claim, and then go on to assert that there is no defense for late payment of wages. Our contention in this matter is that if Mr. Dixon did not agree to accept those wages at later times, and if he brought suit, certainly, then he would be entitled to his damages for his unpaid wages, and under the statute as it reads now, certainly trebling of those damages. We would turn the court's attention back to the facts of this case, distinguished from the hypothetical that the court presents, in that we know that the payments that the city made between March 29th and March 21st and June 29th are not his vacation pay, because the city flatly refused to pay his vacation pay and asked this court to sanction its refusal by saying that these other amounts, which are something else, there's something that the mayor decided to do in the hope that Mr. Dixon would not advance his claim that he was entitled to be employed through December. He also had a claim that he was unlawfully or improperly demoted and reduced in salary, and he was asserting those claims at the time. And so the mayor, in an attempt to resolve the outstanding matters, and that's all the outstanding matters that there were, decided unilaterally to keep him on the payroll and flatly refused to pay his vacation time.
What was the total amount that he was paid, that you say during which time he was an employee, although he did not work?
It was approximately $19,000, Your Honor, and the single damages of the vacation would have been somewhat less than that, approximately $13,000. If you take into account the assertion that Mr. Dixon made that he was entitled to remain on the payroll through the end of the year, if he were successful in that claim, his damages would be much greater than that. His damages would certainly be in the $30,000, $40,000, perhaps even $50,000 range. I've never calculated that number. So what we're left with is this time in which the city was paying Mr. Dixon at a time that Mr. Dixon did not know his status with the city. Was he still employed, as was suggested might be a proper settlement with the city solicitor's letter, or was he fired? But
what would the 5 weeks of vacation time have amounted to?
13,000.
It was 10 weeks, Your Honor, because it was 5
5
weeks
and 5,
and 5.
yes.
And that's somewhat over $13,000. I believe it's around $13,500, but those numbers are in Judge Billings' decision.
Why, Judge Billings decided, going to your second question about whether, anyway, he decided no treble damages, as he had at the time discretion to do. And why do you say that's clearly erroneous?
I say that's clearly erroneous, Your Honor, because Judge Billings did not apply the standard that this court had set out for the meaning of outrageousness. The argument that we had made on the record, and it's reflected in our papers to this court, was that there was reckless indifference to the rights of others, which is the language that comes from this court. And by evidence of reckless indifference, we suggested the fact that neither the mayor nor the human resources director, the two people who admittedly were responsible to ensure that the human resources and wage laws of the Commonwealth were followed, neither of them were familiar with the provision requiring payment of vacation on the last day. As a matter of fact, on the witness stand, the human resources director admitted that she was only somewhat familiar with the law and that the city regularly failed to pay people their pay on the last day of employment. The city
But it sounds like what you're suggesting is that any time there is simply failure to pay, to make a timely payment, that it is automatically outrageous conduct. And that can't be the law.
I wouldn't suggest that, Your Honor. What I suggest is that there were ways for the human resources director and for the mayor to make themselves aware of these matters. The human resources director admitted to being somewhat aware of the 1999 Attorney General's advisory and to being somewhat aware of the Attorney General's poster that is required to be posted in every workplace, which has this language on it.
Well, what if they had been aware? What is outrageous about what they did?
The continual adherence beyond any time when they should have been able to adhere to that language.
So if a payment is made 2 days late, it's outrageous.
If a payment is made 2 days late and the individuals responsible for ensuring compliance took no steps whatsoever to ensure themselves that they are following the conditions of the law, and if those individuals, after having been put on notice of the Attorney General's advisory and this court's decision in EDS2, continue to adhere to the position and continue to assert that they did not have to pay Mr. Dixon his vacation pay and that they still will not pay Mr. Dixon his vacation pay, I would submit that that is reckless indifference. And in that regard, the city took absolutely no steps. Its highest human resources official took no steps to ensure that people who are terminated are paid appropriately. I am an employer, Your Honors, and when I have to take the unfortunate step of discharging an employee, I want to make sure that everything that happens to that employee happens in accordance with the law. And this Court should expect that every employer in the Commonwealth will do likewise, because the wage statutes are not commercial statutes. These are not arm-length transactions. The Wage Act is designed to protect individuals who are low-wage earners or middle-class earners, although apparently in this day and age, middle class means earning $250,000 or less. But putting that aside, the statute is designed to protect people who are not going to know the law and to put the onus in a matter of strict liability on those who should know the law. And the city of Malden...
Liability is one thing. Treble damages is another.
Treble damages, Your Honor, does require a finding of reckless indifference. As we indicated in our papers, we believe that the lack of attention paid by the city in this case amounts to reckless indifference. Thank you for your time.
Thank you, sir.
If it please the Court, Chief Justice Ireland and Associate Justices, my name is Catherine Fallon. I'm the City Solicitor for the City of Malden, the appellee.
How did the city get into this pickle?
Let me concede at the outset, Your Honor, that the failure to pay the wages on the date owed was certainly inconsistent with the terminology of the Wage Act.
You mean the vacation as part of wages, that's what you mean?
That's correct, Your Honor, yes. And I'd also concede right at the outset on the city's behalf that having that forfeiture clause in the vacation ordinance was in contravention to the Wage Act. However, Your Honors, that forfeiture clause wasn't applied to the appellant. And let me just address directly the testimony of the mayor, which is found in the appendix. Specifically, the mayor testified that he continued these payments to Mr. Dixon to resolve his outstanding employment claims. He specifically testified that Mr. Dixon was paid the equivalent overtime of the amount that was equal to or greater than his vacation wages.
Is it correct that he refused to pay vacation wages?
It is not correct, Your
Well, then why
Honor.
did his pay stub continually to reflect the fact that his vacation time balance was not going down as he was getting the weekly payments?
It was the same reflection from the date that he stopped working, Your Honor, until that date. So it just carried on in terms of the payroll system.
So is your answer to Justice Lang's question, was it more that in the mayor's view or his testimony, I don't know what his view is, but what he said was he was seeking to wrap up all these claims and it wasn't that he specifically refused to pay vacation pay. He was just making this payment for all of the claims without differentiating. Is that fair?
That's correct, Your Honor. And we can even get into the specifics of the forfeiture of vacation pay because my brother asked directly to the mayor when the payments stopped, who gave the directive to stop them? And the mayor said, I did, because we believed we had defenses against Mr. Dixon. And when my brother asked, was it defenses as to forfeiture of vacation pay, he said no. He disagreed with that. It was defenses as to misfeasance.
Well, excuse me, but do you agree that the payroll records did not reflect what the mayor believed he was authorizing? Because they didn't reduce the number of vacation days. And he got that month after month after month.
I agree with the fact that it was still tallied, Your Honor, on the document, on the payroll document, but the testimony at the trial demonstrated that Mr. Dixon's last day was March 20th. Mr. Dixon himself admitted that. There was absolutely no question based on the trial testimony that he wasn't reappointed in 2006.
So are you saying that the checks that he received were effectively his vacation pay?
It's the equivalent, Your Honor. Yes, that's what we're arguing. Yes, absolutely. So in action...
Mitigation. I mean, it's as Judge Billings found. That's what you buy into that view of life.
Absolutely, Your Honor. This was actual payments received. So to get these facts down to the figures here, he was claiming $13,615, and he was paid $19,878.
So how is that consistent with the view that he's paying vacation pay if he paid $6,000 more?
And this is why Judge Billings made a determination that not only wasn't he harmed, Your Honor, he benefited.
Right, but try my question. If the mayor, well, did the mayor communicate to Mr. Dixon that you're being paid salary even though you've been terminated because that's your vacation pay being paid over time?
The mayor's testimony was that this was being resolved between councils.
Okay, but again, try my question. Did he communicate, apart from what he said in deposition, at the time it was happening, was there any communication by the mayor or anybody else to say, this is what we're doing, we're paying you vacation pay through this means?
I don't believe so. We can only rely on what the trial testimony was, Your Honor, and the documentation that my...
Your position is that wasn't what he was doing. He was trying to do a global resolution of everything. He wasn't specifically paying vacation pay, correct? The mayor.
The mayor's testimony, you're correct, Your Honor, was to resolve all of any outstanding claims. But what we have here, Your Honor, is it ceased payments at the end of the fiscal year, and then following that is when Mr. Dixon asserted his wage claim.
Can I ask you this, though? If you cite Summers a number of times, but if Summers goes to the point of this is a strict liability case and, you know, there the issue is independent contractor versus employee, but no question, at least the argument of the employer was that that Summers had been paid more as an independent contractor than he would have been paid as an employee. And this court said, sorry, it's strict liability. That's sort of water under the dam. You owe him money because he wasn't paid as an employee. Why is this any different? Whatever the motivation might be, the fact is you didn't pay him vacation pay.
I think it's distinguishable, Your Honor, because the fact of that case is that the employee was denied employee benefits by the misclassification. There was actual deprivation of benefits. There was actual economic loss. We don't have that here. And in fact, Mr. Dixon's sole claim at trial was the vacation wages claim. So what was demonstrated at the trial through the continuation of payments was he received more than that claim. That's distinguishable because the misclassified employees in the Summers case also lost out on employment benefits. In this case, the trial evidence demonstrated Mr. Dixon was continued on employment benefits. And I just want to address, too, in terms of the continuation, there's the two exhibits my brother mentioned. The city did advise Mr. Dixon in December of 2006 that he wasn't going to be reappointed. He and his counsel attended the Board of Health meeting where he wasn't going to be reappointed. Through his counsel's request, they deferred a vote, following which the city solicitor at the time sent a letter to Mr. Dixon, and that letter is quite clear. And that can be found in the exhibits tab 14. Mr. Dixon also submitted his response, and that's in tab 15, where he asked for a salary increase, disputed the fact that he wasn't reappointed, wanted entitlement to credit for retirement benefits that all the other McFadden Manor, the nursing home that he was directing, were receiving, credited to him as well. So it carried itself into a completely different direction based upon these requests.
But isn't the best evidence the payroll records that never reduced the outstanding vacation time?
I don't agree with that, Your Honor. I think that the human resource director's testimony was that sometimes those documents are in error. There are several systems that are working in place in terms of payroll, in terms of the department head requesting vacation time. In this case, the trial testimony was he was the department head, Mr.
But you'd
Dixon.
agree, wouldn't you, that if the vacation days, each time a check went out, were reduced, we wouldn't even be here today, right?
I'm not so sure, Your Honor. I'm not sure
There
about
would still
that.
be the issue about paying overtime versus the...
This is the issue, Your Honor, yes. This is what this case comes down to, is it's actually a matter of proof of damages. Now, what we have here is a claim for $13,000, no proof of any economic loss, no proof of any deprivation of benefits.
Well,
that's the claim that was tried.
Let me ask you this. Let's take it out of the public sphere into the private sphere. Somebody gets fired. They're not given their vacation, their accrued vacation time. But the employer says, I'm going to give you, 10 days. I'm going to pay you for 10 days. And then maybe I'm going to do something else that I don't contractually have to do in order to bid you farewell. Wage Act claim is brought. Can the employer in that circumstance said, well, I paid him these additional 10 days. I didn't have to. Therefore, those should be treated as if they're vacation pay, and there's no damages here because I paid him more than I would have had to pay him for accrued vacation.
I think that it would still require a showing of damages. However, I think based upon the decisional law, the recent decisional law and the legislative change, I don't think that would matter at this point. Because of the mandatory treble damages, I don't think it would matter when any type of payment was made, unless it was made on the date of date of discharge, Your Honor.
You're saying if this happened today, you wouldn't be able to make this argument?
I don't think so, Your Honor.
No, but your point, then I'm not understanding your point. I thought your point was, look, it may be a strict liability case, statute, before and after the amendment, but that doesn't detract from the fact that the employee has to prove damages, and this employee can't. That doesn't change whether you put in mandatory treble damages or you don't.
Yeah, that is the point, Your Honor, yes. That just because of the failure of proof of damages, not being in compliance, yes, it's a strict liability statute, but that doesn't compel the court.
I'm not sure I agree with you, but that is your argument.
Yes,
Right?
that's correct, Your Honor. It doesn't compel the court to grant a party damages where none are proven. And it doesn't compel the court to strict liability doesn't compel the court to determine that a party is a prevailing party either. So that is the point, Your Honor.
Can I ask a question here? Was there ever at any point communicated to the employee why he was receiving the checks, why he was continuing to be paid after he was told to stop working?
There is only conflicting testimony regarding that, and that was handled through lawyers for the city and Mr. Dixon's counsel. Neither of us were representing the parties at that point, Your Honor.
So nothing in writing that basically says you're going to continue to get your pay through X date, but please stay home?
The only thing...
Why you're getting it?
Yes, the only thing is what we've both mentioned to you, Your Honor, which is the correspondence back and forth. And the city attorneys...
Earlier.
That's correct, Your Honor.
That was before he was told don't come back to work, and before he started to just continue to get his paycheck.
That's correct, Your Honor. Yes, yes.
Was there any explanation of why the paycheck ended?
Yes, there was, Your Honor. The mayor's testimony was that he directed that these payments stop because
So I meant the explanation to the employee.
Oh, I'm not sure that
They just stopped.
That's correct, Your Honor, yes.
Was
yes.
there any explanation to the employee, as to Mr. Dixon, as to why he was even getting these payments?
No.
I think that those were discussions.
Does the record reflect anything that was communicated to Mr. Dixon as to why he was continuing to be paid?
Yes, Your Honor. The record contains a letter from the city solicitor at the time explaining your final day will be this day, and you'll be paid on a payroll. The specific terms of his letter were you'll continue to be paid payroll for the vacation leave and for the sick leave. But again, he responded.
What's the date of that letter?
Where does that say that?
That was the city solicitor's letter sent to Mr. Dixon in January, tab 14.
Which said March 2nd or
Oh,
January.
I misunderstood your question, Your Honor. That's the only thing in the record, these back and forth correspondence.
One's in January.
That's correct. And January and Mr. Dixon's response and the trial testimony is all that we really have in the record to determine why these started and why these stopped. And Judge Billings credited Mayor Howard's testimony in the trial. He heard all the witnesses in the matter, he heard all the evidence in the matter, and he found that he credited the mayor's testimony as to why this continuation of payments occurred.
Well, but the judge said that they were not payments for the vacation.
They weren't.
But instead were payments to fend off potential claims that Dixon might assert against the city.
That's correct, Your Honor, but in those payments, that Mr. Dixon recuperated far more than what he was entitled to in his vacation wage, which is why he had no damages.
But we don't know what it was what else he might have been entitled to, because that wasn't the subject of the litigation. This was just a Wage Act claim. So there's nothing that Judge Billings could have adjudicated as to whether or not the employee was entitled to other things, to other payments.
So he could only say what Mr. Dixon was claiming.
Right.
I think the judge determined that he was
Well,
a
how could he
holder.
determine it? The only issue before him was payment of vacation, wasn't it?
I think there were a whole, he did determine it based on the evidence, Your Honor. He determined.
No, wasn't there only one claim at trial, and that involved the payment of vacation, whether it was properly paid and whether there should be multiple damages?
Yes, Your Honor, there was a Wage Act claim, but in the course of the prosecution and the defense of this, there were a number of exhibits submitted, including his status. His status and when it ended did come up in terms of Judge Billings' consideration, and he did determine he was in a holdover status, that he had not been reappointed, and that's found in his decision.
Was the issue of wrongful termination decided by Judge Billings?
It was not, and
Was it litigated?
It was not. He withdrew that. He withdrew all other claims other than the Wage Act claim, Your Honor. And Judge Billings, actually, any discussion, any part of the defense offered with respect to the basis why, it was unpersuasive and uncompelling to Judge Billings. That was he stated that in the decision. It didn't matter. All that mattered was whether or not Mr. Dixon had demonstrated damages here, and he did not. So,
Ms. Fallon, we'll have to leave it there.
thank you.